My dear respected seniors, colleagues, friends, brothers and sisters in legal profession, good morning to you all. I would like to share my feelings about the proposed draft Advocates Amendment Bill 2025 published by the Ministry of Law and Justice Affairs, Central Government of India, with you, so that we can come to a definite understanding of the implications of these proposed amendments. According to me, my friends, the proposed draft Advocates Amendment Bill 2025 undermines the autonomy and independence of the bar and legal profession. As we know well, on 13/2/2024, the central government, headed by RSS-led Modi, proposed to amend the Advocates Act 1961, and accordingly the Ministry of Law and Justice published a draft Advocates Amendment Bill 2025 and invited public response on the draft bill with a avowed object. The object is that the amendments aimed at reform, align the legal profession and legal education with the global best practices. The reforms will focus on improving the legal education, equipping lawyers to meet the demands of rapidly changing world, and raising professional standards. The ultimate goal is to ensure that the legal profession contributes to the creation of a just and equitable society and a developed nation. Further, the said publication asked all the stakeholders and the public to submit their reactions and feedback about the proposed amendments by way of email to dhruvkumar.1973@gov.in and also impel.dla@nic.in by 28th February 2025. My friends, the plain reading of this object of the proposed amendments on the face of it appears to be attractive and laudable one, but the key changes which are proposed to be incorporated by way of amendments ultimately ends in a totally undermining the autonomy and independence of the bar, legal profession, and the statutory institutions which represent the bar, the legal profession, that is the Bar Council of India, and reducing it to another extended arm of the government under the control of the central government. This is in corollary and the philosophy of the systematic dilution of all autonomous and independent statutory institutions adopted and executed by the present government at the center, much against the spirit of the Constitution of India. We have already seen the other autonomous institutions like Election Commission of India and other national level statutory commissions. Central agencies like ED, IT, CBI, etc. have already been totally lost their autonomy and reduced to be an extended arms of the central government and rehabilitation centers by way of quid pro quo pre-retirement favors for post-retirement benefits. Now, the last institution is the Indian judiciary, which the Constitution of India envisaged to be totally independent, free from the interference of the government of the day, as a custodian of the Constitution and to safeguard the fundamental rights of the citizens. The legal profession and the bar being the integral part of the judiciary and is expected to be an independent and free from the control of the government in any manner and in all aspects. That is why, to protect the interest of the legal fraternity and to govern the functioning of the bar associations, a statutory institution like the Bar Council of India at the national level and the state bar councils at the state level are constituted under separate law. The Constitution of India have envisioned not only the independent judiciary and legal profession, but also provided the checks and balances in between the parliament, executive and judiciary by separation of powers to achieve the objects as enshrined in the preamble of the Constitution, which is repeatedly declared as the basic structure of the Constitution and cannot be meddled or altered or diluted in any manner, either by the Parliament enactment or by the government in any manner, as upheld by the various Supreme Court judgments. The Supreme Court of India in Keshavananda Bharati versus State of Kerala 1973 case declared that the true position is that every provision of in the Constitution can be amended provided in the result the basic foundation and construction of the constitutions remains the same. The basic structure may be said to be consisting the following features, that is the supremacy of the constitution, republic and democratic form of government, secular character of the nation and constitution, separation of powers between legislature, the executive and the judiciary with checks and balances, the federal character of the constitution. The same principle was also reiterated by the apex court in Indira Nehru Gandhi versus Rajnarayan 1975 by holding that if there is any part of the constitution which deserves greater devotion than any other part of it, it is certainly the preamble of the constitution. That is why Baba Saheb Ambedkar, the father of the Indian constitution, described the preamble as a way of life which recognized the liberty, equality and fraternity as principle of life. In state of Bihar versus Bal Mukunda Shah 2000, the Supreme Court reinforced the principle of separation of powers and emphasized the principle of an independent judiciary. The independent judiciary of which the legal profession is also an integral part. However, the proposed amendments are totally against the cardinal principle of maintaining the independence of the legal profession, bar, and its representative institutions like Bar Council of India and State Bar Council. It is not only poorly drafted, but also failed to address the real issues faced by the legal fraternity. The key changes which are proposed to be incorporated in the Advocates Act 1961 by way of these proposed amendments as per the proposed draft bill are as follows. The number one, the insertion of section 35A. The section 35A prohibits boycotts and abstentions from the court work. No association of advocates or any member of the association or any advocate, either individually or collectively shall give a call to boycott or abstain from the court's work, or boycott or abstain from the court works, or cause obstruction in any form in the court functioning or in the court premises. Number two, violation of clause 1 shall be treated as a misconduct and shall be liable for disciplinary action as contemplated as per the acts and regulations. And the proviso to this clause 2 states that the advocates may participate in strike only when it does not impede the administration of justice, such as the strikes intended to bring legitimate concerns about the professional conduct, working conditions, or administrative matters, and may include a symbolic or one-day token strike as long as they are conducted in a way that does not disrupt the court proceedings or violates the client's rights. Number 2, Section 1, subclass B and Section 1, Class B and subclass 2 to be inserted to investigate into the allegations of the misconduct when advocate engages in strikes in violation of Section 35A. It talks about constitution of a special public grievance redressal committee of the Bar Council of India. And here it must be noted that the Bar Council members are not the members. The committee shall have former Supreme Court judge or a Chief Justice of any High Court or their nominees as a chairperson, member from the Bar chairperson, 2 retired judges of different High Courts, 1 senior advocate, and one member of the from the Bar Council of India. On the report of this committee, once the report of this committee is given to the general body constituted under the Act, the BCI may accept the findings and seeks appropriate remedy or refer the matter to initiate the disciplinary action. Further, as per the proposed Section 26A, the State Bar Council may remove any advocate from the state role if he is found guilty of serious misconduct or causing obstruction in the court functioning. Number 3, insertion of section 24A and section 24B. As per the proposed section 24A, the State Bar Council may not enroll the person convicted for an offence for 3 years or more. If they are to be enrolled, the permission of the enrollment committee of the State Bar Council will be required as per section 24B. The names of the advocates who are convicted and sentenced for the offence punishable for 3 years or more shall be removed from the state roll, provided if the period of the sentence is less than 5 years and after 2 years have been elapsed since his release, the advocate may make an application to the State Bar Council for re-enrollment. Number 4, insertion of section 33A, registration of an advocate with a bar association. An advocate with the Bar Council engaged in or intends to practice before a court, tribunal or quasi-judicial forum or any other authority shall get himself or herself registered as a member of the Bar Association where he ordinarily practices or intended to practice the law. In case of any advocate leaves one bar association and joins another bar association by reason of change of place or practice or by reason of any change of the field of law, he shall intimate such change to the bar associations of which he is a member within the period of 30 days. No advocate shall exercise the right to vote in more than one bar association. Now, as of now, we have got a right to practice before any court, any court anywhere in India. Yeah, next, number 5, insertion of section 45B, liability of misconduct in certain cases. If any person suffers loss caused deliberately or by misconduct of an advocate, then such person may make a complaint of misconduct against the advocate under the appropriate regulations as may be prescribed by the Bar Council of India for deciding the liability of advocate. Number 6, insertion of section 49A, entry of foreign laws, entry of foreign laws and firms. As per the proposed insertion of clause C, subclause CC after clause C to section 49A, clause 1, the central government now has the power to make rules governing the entry of foreign law firms or foreign lawyers in India. Further, section 49A has also been proposed, which allows the central government to give directions to the Bar Council of India necessary for carrying into the execution of any provision, rules or orders made thereunder. Then number 7, insertion of section 4, clause 1, subclause D. The draft bill introduces section 4.1, subclause 1D, giving power to the central government to nominate up to 3 persons to the Bar Council of India. So even in the administration, the central government will have say from now onwards. If this proposed amendment bill became an enactment. Then number 8, definition of legal practitioner expansion, and deletion of practice of law definition as proposed by the Bar Council of India. Section 2, clause 1, which defines who is a legal practitioner, now includes any advocate or any law graduate engaged in the practice of law before courts, tribunals or quasi-judicial forum or doing legal work in any private or public organization, including but not limited to statutory and autonomous bodies, domestic and foreign law firms and corporate entities. So the wider definition, expansion of definition of legal practitioner. There are number 9. There are other deletions of important definitions and sections in the proposed amendments which have far-reaching consequences adversely affecting the autonomy and independence of the bar and legal profession and their representative bodies such as Bar Council of India and State Bar Councils. The careful reading of the above mentioned key changes proposed in the draft amendment, Advocates Amendment Bill 2025, drives us to the irresistible impression and inference that the Indian intention of the government is not only to undermine the autonomy and independence of the bar and legal profession, which is the only ultimate hope of upholding the democracy, democracy, constitution, fundamental rights and the rule of law being integral part of the judiciary, but also to make it totally redundant and only a silent stooge of the government. It is obvious that the government wants to have an absolute control over the legal profession as well. Functioning of the Bar Council of India and state bar councils totally losing their autonomy and to dance to the tunes of the government policies and abdicating its fundamental right and responsibility to stand for the equitable distribution of justice, rule of law, protection of the Constitution of India from the autocratic majoritarian tendencies that are rapidly growing and heading towards reverting back the independent India into a dictatorial and autocratic state. We all know that the Bar Council of India and state bar councils are autonomous bodies having statutory structure and independence with a democratically elected governing bodies representing more than 27 lakhs of advocates of the country. The proposed amendments are draconian in nature and totally undermines this independence of the legal profession and their representative bodies. The proposed amendments were never circulated to any of the bar councils or in the public domain or to the bar associations throughout the country to solicit their views and suggestions for making the legal profession more vibrant, responsive, independent in upholding the constitutional mandate and the rule of law and dispensation of justice. Instead, these proposed amendments came as a bolt from blue, that is a lightning strike to the legal fraternity and shocked the entire legal fraternity. This totally one-sided and arbitrary amendments, turning the government into a governing and regulated body of the legal profession altogether, and Bar Council, denying their autonomy and self-regulation, totally diluting their independence, prohibition imposed on the legal fraternity and bar associations from raising voice against injustice, violation of rule of law, autocratic tendencies of the government and institution, expression of fundamental right of dissent, and defending the constitution and rights of citizens in all possible ways. By proposed amendments in respect of the boycotts or strikes or abstention from the court work, which is a democratic way of expression of dissent, opposition, resentment, and highlighting the problems before the public, which is in perfect consonance of the constitutional spirit. By prohibiting boycott, strikes, and abstention from the work is a clear draconian measure which is not at all thinkable and acceptable either by the bar associations, legal professionals, and their representative bodies, BCA or other state bar council, and it should be opposed tooth and nail. The proposed draconian measure of controlling the functioning of the Bar Council of India by nominating its representatives in the executive body of the Bar Council is intended to not only to control, dominate, but also dictates the terms of the functioning of the legal profession. Further, even the proposed amendment of nominating the retired judicial officers in the disciplinary committee to regulate the conduct of the advocates when the statutory and elected committees, bodies, Bar Council of India and state bar councils have got their own disciplinary committees and are in existence as per the statute, is nothing but to intimidate, threaten, and dominate the entire legal profession, which also should be opposed and rejected outright. Further, usurping the power to supervise and give general instructions to the state bar councils and to constitute a committee comprising former judge of High Court along with senior advocates to administer the state bar councils when it is not able to perform its functions for any reason is also another draconian measure which should be rejected. Likewise, the entry of foreign advocates or legal law firms without the consent, scrutiny, and approval of the Bar Council of India and their abiding by the rules and regulations of the bar councils and the law of the land and the respective bar association will totally and adversely affect the legal profession and advocates and create unhealthy competition and confusion in the functioning of the legal profession, which must also be opposed and rejected. As of now, there are Bar Council of India and respective state bar councils elected, constituted under the statute have no absolute right even to regulate and interfere into the internal administration and management of the bar association as an apex representatives bodies. Thus, the bar association are also autonomous within their purview so that they can independently, fairly and fearlessly stand for the justice, stand for their clients individually and collectively as well. But the proposed amendments and also the change of definitions and adding of definitions to the terms of legal profession, legal practitioner and practice of law, etc. are also prima facie appears to be against the spirit of independence of the legal profession and bar associations. Under the circumstances, it is imperative for all the bar associations, learned advocates and members of the legal fraternity and their representative bodies such as bar councils must rise up to the occasion and oppose all these proposed amendments vehemently in one voice, in all possible ways and methods, including securing the cooperation of civil society and people at large, to force the central government to totally withdraw and drop the proposed amendments at once. It is a welcome sign that the Bar Council of India has responded to these proposed amendments by registering its opposition with the said proposed amendments and requested the central law minister to make amends for the same. But that is not sufficient. The entire legal fraternity and the bar associations must become one to protect their independence and integrity and made the government to withdraw the proposed draft advocates amendment bill in toto. I sincerely hope that we will succeed by standing united in this most essential and sacred duty of upholding the dignity, integrity and independence of legal profession and bar associations. Thank you. Yours lovingly and yours sincerely, Y.Jayaraju, Senior Advocate, President, National Lawyers Forum for Social Justice. Thank you very much.